What is a voidable contract? To understand what a voidable contract is, one must recognize a stark difference between the legal terms void and voidable, so as not to confuse these legal terms and misapply them in their application to contractual matters and other legal arrangements. For when an instrument or transaction is void, it is an absolute nullity that nothing can cure, and that precludes the instrument or transaction from having ever taken place, as held in the 1916 Supreme Court of Canada decision, Heron versus Lalonde, such that it is nulle initio. By comparison, where an instrument or transaction is voidable, it presents an imperfection or defect that can be cured by the act or confirmation of the person who could take advantage of it. Thus, acceptance of rent will make good a voidable lease, yet it will not affirm a void lease. For a contract to be void, it is of no effect whatsoever, being a nullity that is incapable of confirmation or ratification. Justice Deschamps, in the 2011 Supreme Court of Canada case iTrade Finance versus Bank of Montreal, affirmed the long-standing proposition put forth by Chief Justice Fitzpatrick in the 1917 Supreme Court of Canada case Bolliff Grain Company versus Ross that, quote, "What is only voidable and not void cannot be held as invalid until it has been rescinded. It is not enough to avoid the contract, that nothing is done to affirm it, it must be disaffirmed," end quote. As such, a voidable contract can be voided if the adversely impacted contracting party takes the requisite legal action to disaffirm it or otherwise invalidate it is taken. But if either no action is taken or an action is taken that validates the contract is legally effective, and the adversely impacted contracting party could well find themselves legally bound to it, irrespective of its pre-existing voidable characteristics. Nevertheless, for the adversely impacted contracting party to trigger a voidable contract, they must disaffirm the contract in its entirety and in a timely fashion. Otherwise, they lack the prerequisites to void the contract. Contracts can be voidable as a result of 1. Mutual mistake of fact, although this is not as simple as common mistake, being a considerably higher standard where available and based upon legal precedent of the jurisdiction. 2. Where a contracting party lacks the requisite capacity to enter the contract at the outset, such as being due to their age or from intoxication or mental impairment. 3. Where a contracting party's consent was obtained through coercion, undue influence, misrepresentation, or fraud. And 4, as may be provided by statute or legal precedent in highly specific situations. Thank you.